Hi, my name is Yinxi Jiang. In today's presentation, I will share my research with respect to the director's duty to prevent insolvent trading and available statutory defenses. The presentation covers 5 parts. Firstly, I will introduce fiduciary duties of directors in a corporation. After that, I will briefly demonstrate what is insolvency by law. Based on these underlying understandings, it is much easier to perceive the importance of directors' role in prevention of insolvent trading. Last but not the least, I will outline the consequences of breaching duty to prevent insolvent trading and also defenses available to directors. According to Jensen and Merklin famous theory of contractual nexus, the corporations are nothing more than nexus of contracts between various parties, including shareholders, customers, creditors, and so on. Under the modern corporation regime, shareholders delegate their rights of decision-making to managers and directors, and those managers and directors sign different contracts to benefit the business, including contracting with creditors for operating and financing. Under Australia's Corporations Act, Section 95A defines insolvency as a person who is unable to pay all due payable debts. In the case of ASIC versus Fleming, general law indicia of insolvency includes continuing losses, low liquidity, inability to finance, and so on. We can find the fact that insolvency is a serious situation. If an entity is insolvent, it cannot pay debts, and furthermore, it can hardly finance for further operating and investing activities. In this case, the shareholders' benefits regarding the business impaired, and the creditors cannot get their money back. So it is important that the directors exercise their managerial powers so fairly, with due care and diligence to prevent insolvent trading of corporation. This is the importance of directors' duty to prevent insolvent trading. About the director's duty with regard to insolvency, Section 181(1)(a) requires that directors owe duty to act in a good faith, in the best interest of the company, and the case of Kinsella and Russell Kinsella demonstrates the rule that in an insolvency context, the best interest of the company transformed from those of shareholders as a whole to the best interest of creditors. Moreover, Section 588G indicates that directors' duty to prevent insolvent trading is breached. A person is a director when the company incurs a debt during or making the company's insolvency, and it is reasonable to suspect that the company's context of insolvency. At the first part of Section 588G1, a director is defined under Section 9, appointed de facto shadow or accountable for director. The incurrence of debt is when company is exposed to unavoidable liability to pay, illustrated in the case of ASIC versus Fleming. All the time can be some other circumstance that causes the company to owe a debt, such as issuing dividends. In the case of ASIC and Fleming, the reasonable grounds to suspect insolvency is important to consider as directed. This requires director to be reasonable, competent, diligence to suspect insolvency. In general, a director has duty to prevent insolvent trading under Section 588G. If a director breaches the duty to prevent insolvent trading, he may face civil penalty under Section 588G2. The civil penalty includes compensation order under Section 588G and 1317H, or pecuniary order under Section 1317G, or disqualification from managing a corporation according to Section 206C. Criminal offenses under Section 588G3 lead to more severe penalties, including penal units and imprisoning. While the directors may breach the duty to prevent insolvent trading, Section 588H provides various statutory defenses available for the directors. Section 588H2 provides that a director can defend himself against the company's solvency if it is reasonable to expect the company was solvent and would remain solvent by incurring the debt. This principle was well explained in the case of Hall and Pullman. Furthermore, a director has defense under Section 588H3 if it is reasonable for him to believe in the solvency of the company based on the information provided by a competent, reliable, and reasonable person. This statutory defense was demonstrated in the case of Manpack Industries. Another defense is available under Section 588H4 that if the director has a good reason not to participate in the management at the time of incurring the debt. And Section 588H56 provides more available defenses regarding whether reasonable actions have been taken to prevent the company's insolvency. That is the end of my presentation, and thank you for your listening. And here is my reference.